and we're specialists in the area of household employment, payroll, tax, and labor law. And I am thrilled to be joined today by a legendary accountant, Sid Kess. How are you doing today, Sid?
Doing great, Tom. Thank you so much for your introduction. Tom, as an attorney and a CPA, I find that most professionals like myself have never had any formal training when it comes to payroll taxes. In accounting and law school and in the LLM program I took, I never had any tax course that gave us any exposure to the area of payroll taxes. And yet, just in my own personal life and with friends that I've been involved with, a knowledge of this area is so critical, both in my professional life as well as for my clients. Let me give you some examples. Aunt Jen, she passed away at 101. Before going to the nursing home, she needed a caretaker. Betty, my long-term friend, developed dementia in the early stages of Alzheimer's. Can't be left alone. She needs a sleep-in with her all the time. Lydia, one of the top lawyers in the country, had a nanny for her children when she was a full-time lawyer. And then what happens is she remarries. She has a husband in his 80s. He develops all kinds of problems. They need a caretaker to take care of him. Martha, my French teacher, was alone, and she reached her 90s. She needed a companion. And in your own family or in your client's family, how to handle household help is frequently overlooked or mishandled. And with an aging population, senior care needs are growing rapidly. And understanding these rules, as well as the new legislative developments that Tom Breedlove is going to discuss with us today, is more important than it's ever been. And failure to comply with these rules can prove to be very costly. And Tom is going to help us go through the major changes in household employment, what every practitioner should know. And we, as advisors, need to be proactive. Our clients can't wait until tax time or neglect to act or fail to comply with the rules. They will have already made a number of expensive and time-consuming mistakes. So as advisors, we need to help them understand that it's much cheaper, easier, and less risky to handle this directly during the hiring process. And when you wait till the tax season, it's too late. And household employment is quite different than commercial employment. The payroll process is a lot different. The labor laws are different. Family needs are very different than commercial enterprises. So when you're helping clients in this area, I advise you to steer them to a specialist in household employment. And a firm like Care.com Home Pay does this every day and is set up to provide expert support to your clients. Now, there have been several major changes in household employment. And it's a great pleasure for me to reintroduce Tom Breedlove, who's director of Care.com Home Pay, and who is going to talk to us on these major changes in household employment. Tom brings 30 years of business experience, including more than a decade, in the executive team of Breedlove and Associates, now Care.com Home Pay. It's the nation's leading household employment specialist. He's co-author of the book, The Household Employer's Financial, Legal, and Human Resource Guide, and has been an active speaker on this complex topic. And as director of Care.com Home Pay, Tom is a leader of a national service firm focused on delivering a comprehensive solution for busy families that have care in the home and handling all of the state and federal employee requirements that relate to payroll, wage reporting, tax remittance, labor law compliance, and tax agency correspondence. Tom, would you please let us know a little about the major changes in the household employment area.
Wow, thank you, Sid. That was an outstanding introduction. I appreciate that. You hinted at this, and I think it really is an important point there. Many tax practitioners have not had to spend a whole lot of time dealing with household employment in the past. It's a segment of the industry that for many years was predominantly paid under the table, and many people kind of looked the other way. But there's a couple of things that are happening this tax season that I want to make sure everyone is aware of.
And you know, Tom,
yes.
I think the average practitioner doesn't even know where to look to find out about this.
Well, I think you're right. It is so nuanced and such a small part of the tax code that it frequently gets overlooked. But I do think there are a couple things that are happening this tax season. They're going to make this a much more prevalent conversation for many tax practitioners. And the first issue that's driving that is the Domestic Worker Bill of Rights legislation. It has passed in several states around the country: California, New York, Massachusetts. It goes into effect in April. Hawaii. There are another half dozen or so states that have bills pending. But what's happened with that, even though it hasn't passed nationally yet, what's happened is it's created an enormous amount of awareness among caregivers and domestic employees in general as to what their rights are as workers in the United States, and the understanding now that the payroll system, the payroll tax system that we have in the United States, funds a lot of critical benefits like Social Security and Medicare and disability and unemployment and things like that. And now that they know that those rights are entitled to them, they are speaking out more and more, asking more questions to their families that they work for. How do I make sure I get these benefits? What do I need to do to make sure I'm paid legally so that I can get these benefits? And as those questions come up, they're spreading like wildfire. And of course, with social media, the caregivers are talking to each other across the country. So really, a lot of families, even outside of the states I mentioned before, are being asked these questions. And so the laws are coming into play a lot more than they have in the past. So that's a major area.
Tom, I'm sorry to interrupt you, but
okay.
let's say a state other than New York or California has not enacted the household domestic workers' Bill of Rights.
Mm-hmm.
Would an employee have some of these benefits even though the state doesn't have the legislation enacted? For example, overtime pay or rights to vacation or sick pay?
That is generally correct. Things like overtime are driven by the Fair Labor Standards Act, which is a federal law. And so that law has actually been on the books for years, and it governs really all states. They can make overtime more strict, but they can't deny access to overtime for the workers. So what's essentially happened is the state statutes are really drawing attention and putting specific state regulations on the books that just reinforce the federal law. But even if you live in one of the states that doesn't have legislation passed, the laws like overtime still apply, and in many places, paid sick leave or paid time off comes into play. It's very nuanced by state, but the federal law does apply everywhere. So it's something that now that people are understanding what they're entitled to, they're demanding those rights. So thank you for bringing that up. The second issue that's affecting and impacting families more than it has in the past is the Affordable Care Act. It's kind of an interesting scenario. A lot of people think of it from the standpoint of the employer mandate. Household employers are not covered under that mandate, so they do not have to provide health insurance for their workers. But the individual mandate still applies, and many domestic workers fall under the threshold, the 400% of the federal poverty level. So they're entitled to subsidies to help pay for the mandatory health insurance now. But in order to get this subsidy, they have to have documented wages. So we're anticipating that this tax season there's going to be quite a few caregivers and other domestic workers who approach their families about a W-2 so that they can get their health insurance subsidy from the federal government. So those two factors are, I think, going to drive a lot more questions from your clients, and I think bring this to the forefront and out of the shadows. So I'll jump now into some of the things that we want to make sure everybody's aware of now that everybody understands kind of the backdrop. Next slide, please. And let's go ahead to the, let's kind of start from the top. Who is a household employer? There's sometimes this confusion as to who's technically considered a household employer. And really the definition from IRS Publication 26 is that if a family employs an individual to perform duties in or around the home, and they have the right to control when it's done, what's done, where it's done, by whom, then they're legally considered the employer for all practical purposes, for tax and labor law purposes. So, you know, lawn service would not count. That would be more of a commercial relationship. And there are certainly some lawn professionals who sort of operate as independent contractors. But generally speaking, if a family employs a nanny or a senior caregiver, housekeeper, private nurse, personal assistant, you can go down the list, they are going to be considered a household employer by the IRS. So that's a real important thing to note. I'm going to talk a little bit more about worker classification in a minute, so we'll do a deep dive into that. But that's kind of how the IRS views it. If you go to the next slide, I'll kind of walk through real quickly what the obligations are from a tax standpoint. Probably many of you have heard the term nanny tax. That is a term that was coined by the media a number of years ago when Zoe Baird was nominated to be the Attorney General for Bill Clinton, and she was discovered to have paid her nanny under the table, and so the media labeled it Nannygate, and then later it became the nanny tax obligations. But essentially, those obligations are somewhat similar to that of a commercial enterprise in that you have to withhold payroll taxes, Social Security, Medicare, and any other applicable state taxes from the employee's pay, or else you as the employer are required to pay it for them. So it becomes your liability if you don't withhold it properly. The second part of the nanny tax obligation is obviously they will have some employer taxes. The matching of Social Security and Medicare are the two biggest ones. There's also some unemployment taxes, both at the federal and the state level. You know, combined, those taxes tend to be about 9 to 10% of the gross wages. But the good news is, and I'll cover this in more detail, the good news is that tax breaks will typically offset most of the employer tax costs for families. And we have a calculator on our website to help families understand their tax liability as well as their tax breaks. And when you net it all out, frequently families are actually come out ahead. And if not, it tends to cover the vast majority of their employer tax costs. So pleasantly surprised, it's not nearly as scary from a financial point of view as most people assume it is. Then the third obligation is to file state and federal tax returns. Now the state side is typically done on a quarterly basis. So once you establish your state tax IDs, you file state quarterly tax returns. There are a few states that have annual filing, they allow annual filing under certain conditions, and there are a few states that actually require deposits more frequently than that, and you reconcile at the end of the quarter. But essentially, there's state filings throughout the year. And then on the federal side, those taxes can be remitted at the end of the year through the 1040, or they can be handled through 1040 ES process throughout the year. Since the federal taxes tend to be bigger dollars because of all the Social Security and Medicare and federal income taxes withheld, we typically handle that for our clients under the 1040 ES, so we'll make those payments throughout the year, and then we don't have to worry about any liabilities or underpayment penalties at the end of the year. And then the fourth obligation all comes at year end, where the employer has to provide a W-2, obviously, file a copy of the W-2, copy A and Form W-3 with the Social Security Administration, and then the final piece of it is to file Schedule H with the federal personal income tax return. So, the Schedule H actually shows as a liability. Shows all the wages paid to the employee and shows it as a liability. We provide, the practitioners that we work with, we provide that Schedule H to them and also include all the federal payments that were made throughout the year so that they can offset those on the 1040.
Now, do you also pay the estimated taxes along during the year?
Yes, we do.
The state?
We allow families to opt out of that if they have a practitioner that is handling all of their 1040 ES payments throughout the year. If they want to, they can opt out. But frequently, the easiest way to do it is for the practitioner will likes us to go ahead and do the 1040 ES payments on the household employment obligations, and they'll handle the 1040 ES for the rest of the tax world, and then we don't have to worry about any underpayment penalties. So those are the tax obligations if someone pays an individual $1,900 or more in a calendar year. So that's the threshold. It is continuing through 2015. So it's $1,900. That's called the casual babysitting exemption. If you pay under that, you don't have to worry about all the reporting. But if you pay $1,900 or more, you do. So next slide, please. I'll jump now to the labor law obligations, because this is a part that many families struggle with because they don't have an attorney or an advisor or somebody to tell them what the labor law issues are, and they've become more stringent over the years. In most states, a written wage notice is now being required at the time of hire. Some sort of contract or written wage notice is being required. It's not true everywhere because it's not part of the federal law, but it's becoming more and more prevalent. Not only that, it's a really, really good idea to put it all in writing, and it tends to prevent a lot of problems, but it's also mandatory in many places. So that's one thing that families need to know. The second thing is that in most places it's also required that the employer provide detailed pay stubs, and they have to showcase all of the hours worked for that pay period, all the regular and overtime rate of pay, all the taxes withheld, both in the pay period and also year to date. So that's something that many families struggle with, trying to document and provide professional pay stubs, but that's something that specialists like us, obviously would take care of. Then you have to make sure that you're adhering to minimum wage and overtime standards, and that has become trickier now that many municipalities have different minimum wages than their state, and the state sometimes has different minimum wages than standards in the federal law. So generally speaking, the highest of those three would apply, so we have to comply essentially with all law, federal, state, and municipal, but you have to kind of keep up with all that, and it's not easy for families. And I'll go into more detail on overtime, but overtime is also a really tricky issue with incredibly high potential expense to families, so I'm going to actually dedicate a whole slide to that in a minute. We also have to worry about making sure that we reimburse employees for mileage and any other expenses that are incurred on the job. That's required by law in many places. Workers' compensation insurance is also required by law in about 30 states. And I'm going to do another slide on that because that is an important, very important point of exposure for your families. And I want to make sure everyone is aware of how that works. Disability insurance is required in 5 states. The other states don't require it, but it's something that's optional, and a lot of families decide they want to do it once they kind of understand how it works. And then, as Sid mentioned earlier, there are a number of places now where paid time off is required, either in the form of vacation or paid sick leave or both. So there are nuances by jurisdiction, and our site covers that. So if you have a question about your particular state or even the city that you live in, you can probably find it on our website, and I'll talk about that resource here in a minute. Next slide, please. Okay, let's jump now to the things that I want to highlight for everyone so that you can help your families avoid common mistakes and really expensive problems. Like Sid was saying, prevention an ounce of prevention is worth a pound of cure, and if you know what the big issues are, I think you can serve your clients, do a great service for your clients, because trying to decipher all the federal and state law in this little nuanced area is really tough for busy families. So they will inadvertently make a mistake if left to their own devices usually. And the first major area that I want to cover is worker misclassification. As many of you probably know, the IRS has a test, a 20-point test to determine really control, who has control within the working relationship. And that test is just ambiguous enough to where, if you're a family and you really don't want to deal with paperwork, you could probably look at it and say, you know what, I think she might be considered an independent contractor, and then I don't have to worry about all this paperwork. I want to warn everybody that the IRS has a very strict policy on kind of their interpretation of that control test. And 99 times out of 100, they will deem the family to be the employer. They want one throat to choke, and they want to make sure that all the taxes are handled properly and everything. So they look at it as if the family has the right to control. They don't even have to control everything in their working relationship, but if they have the right to, then they are deemed the employer, and the worker cannot be called an independent contractor. And it really doesn't matter how many hours she works. It doesn't matter how much or little you pay her. It doesn't even matter if she agrees to it in writing in a contract. They still view it as, if you are in control of the relationship, then you have all these employer responsibilities regardless of what's in a contract. So that's an important thing for everyone to know, because it can be a very expensive mistake, because, as I mentioned before, there would be back taxes both on the employer side and the employee side because of the requirement to withhold the employee's FICA taxes. And if the family doesn't do that, then they would be liable for that. So between that and penalties and interest, it can be a very expensive mistake. And to kind of exacerbate the issue, the Department of Labor and the IRS have teamed up in the past couple of years to increase enforcement on worker misclassification, and they've actually cited the household employment industry as one of the targets for their enforcement. So this is a really important and serious thing for your families to know about, and I can tell you from experience that when I read parent forums, I am always appalled. There's just an enormous amount of misinformation floating around on the web, and families, lay people will provide families with bad advice on this topic. So I want to make sure that you know what the law is, and you know that when we petition to the IRS using Form SS8, we get consistent rulings back from the IRS that worker should be deemed an employee and not an independent contractor. So over the years, we've we've just seen so many horror stories in this area. I just want to make sure it doesn't happen to one of your families. Next slide, please. The second major area that it probably won't be a surprise to anyone on the call today, but families, over and over, we hear families talk about the nanny taxes, and they go through the hiring process, and they're so happy to hire a nanny or a senior caregiver or whoever. And the whole idea of the quote-unquote nanny taxes, it feels like tax stuff, and it feels like something that you just handle at tax time. So I can't tell you how many times families just procrastinate. The hiring process maybe was a little bit more involved than they had hoped, and now they're ready to get back to work. The caregiver's in the home, they're happy, they're relieved, and they just say, you know what, I'll deal with this at tax time. And oftentimes they probably drop this on your desk in February or March and say, oh, by the way, I had a worker that worked for me all year. And then that presents you with the challenge of trying to figure all this stuff out. But I can tell you from experience that when families procrastinate and wait until tax time, just like Sid was saying, they have probably made a number of expensive mistakes. They probably failed to withhold the taxes properly. They've probably failed to file employment tax returns throughout the year like they're supposed to, so they have delinquent issues there. And then they probably made a number of labor law violations, particularly overtime. So if you took nothing else from this presentation, I hope you would take away the notion that if you can proactively work with your families to get help somewhere at the time of hire instead of waiting until tax time, that would be a major gift to your families. They need to see that hiring someone is an employment issue and an HR kind of issue, not a tax return issue at the end of the year. So getting them involved and to find a solution at the time of hire is just absolutely critical. So I hope everyone makes a mental note on that. Okay, next slide, please. Okay, a third area that I want to talk about is it's a very common mistake for families to put a domestic worker on the company payroll. And oftentimes it's very well intended. The thinking is I already have kind of a system, and I already have benefits, and I already have all these things through my office, so why not just throw my nanny or my senior caregiver on the payroll, and it'll just make things easy. And I am reporting those taxes, and I'm even withholding and doing everything I'm supposed to do, so why would anybody care? And that's kind of the mentality. But the problem is the IRS provides, obviously, tax deductions for payroll expense, but every employee on the payroll has to be a direct contributor to the success of the business. And the IRS has ruled that domestic employees are not direct contributors to the business, they're direct contributors to the household. And they've even heard there's been cases from CEOs who said, you know what, if I run the company with the help of my nanny at the office, and if I didn't have her, in the executive suite there taking care of my child, I wouldn't be able to run the company, so I consider that a business expense. And the IRS says, no, that's a personal expense, and if she's up there filing, then that's a business expense, but if she's taking care of your child, then that's a personal expense. And by the way, you can take the tax breaks on your care-related expenses to your personal income tax process, but you're not allowed to report the wages or take deductions on your business taxes. So that's an important thing for everyone to know, that the IRS has ruled on that, and they see it as a big no-no. We've had a lot of clients who've had to go back and amend all of their corporate tax returns and then all of their personal tax returns to shift the wages, and it's a real pain. The only two business entities that are allowed to even report wages from a household employee are sole proprietorships and for-profit farms. But even those two business entities are not allowed to take the business payroll tax deduction. So it's important for everyone to know that. I also would probably chime in, and Sid might want to add to this, but since he's a lawyer, but from a legal point of view, it's wise to keep these two types of payroll separate for asset protection reasons. We have seen a number of cases where a caregiver filed a wage dispute against a family, and the plaintiff attorney, found out that they were paid through a company that had much deeper pockets than the family did, and they were able to get judgments that were much larger than they would have normally because they named the corporation in the wage dispute. So just a word of caution. I want to make sure everybody's aware of that. Next slide, please. Okay, overtime. We'll jump into this real quick because this is a really, like I said, a really expensive potential problem for many families. And I think it stems from the fact that most of your clients who are wealthy enough to hire a caregiver in the home are probably professionals who are exempt from overtime. They probably are paid a salary and sometimes work 50, 60 hours a week and never get another penny for it. So the mentality for a lot of those folks is to say, you know what, if I put my caregiver on a salary, then I won't have to worry about overtime. I won't even have to track hours. It'll be so much easier. They don't understand that the overtime laws are not determined based on whether it's a salary or an hourly position. It's based on the type of worker, and domestic workers are considered non-exempt workers. So they are entitled to be paid for every single hour that they work, and they have to be paid for time and a half for every hour over 40 within a 7-day work week. So the idea of a fixed salary is absolutely illegal in the household employment space. You can pay a salary out of convenience, but if the hours go over 40 and they fluctuate, you need to pay at the overtime rate for those extra hours. So that's a really important thing to note for your families. Many of them, have 45, 50-hour work weeks for their caregiver and don't pay overtime, and there is no statute of limitations on overtime disputes. So a former disgruntled employee could come back. We've seen it happen a number of times. They come back 5, 6 years later and sue the family for back overtime wages, and it is extremely expensive problem if you get hit with that. And I will make a note on here that federal law has an exemption for overtime if the employee is a live-in. And so that's an important thing to note. Not too many families have live-ins these days, but if it is a live-in, there's a federal exemption, but again, there are nuances by state. There's a handful of states that have their own overtime requirements for live-in employees, and so you have to be really careful about that. Again, that's on our website, and when we get to the resource discussion, I'll draw attention to that where you can find that information. Okay, next slide, please. I want a couple more points on overtime. First, there is this is an important thing to note for any clients you have that might have around-the-clock care. There is a federal 24-hour shift law that says that a family could treat up to 8 hours of sleep time as non-compensable hours. So you don't have to pay the caregiver for those up to 8 hours, as long as adequate sleeping facilities are provided. She's able to sleep at least 5 hours of continuous sleep, and she agrees to it in writing. So if those conditions are met, then a family could have someone work around the clock, 24-hour shift, and only pay for 16 hours of work time. So that's a great way for many families to save money. I will say that if anyone here has clients in California, There was just the California Supreme Court just announced last week that sleep time had to be compensable in California unless it was specifically exempted in a wage order. And the wage order that covers domestic workers is Wage Order 15 in California, and it does not have an exemption for sleep time. So this federal 24-hour shift law is applicable everywhere in the country except California until the Wage Order 15 gets modified, which we don't know if it'll happen. California residents would have to pay for every hour. So then I also want to bring up companion care. There's been a lot of discussion about companion care in the past year and a half or so. Essentially, companion care was defined by the Fair Labor Standards Act in the Department of Labor many years ago, about 4 decades ago, and it essentially created a subcategory of caregiver that was, and the goal was to try to provide less, basically non-medical care that wasn't quite as professionalized, and make that care a little bit less what I would call like professional employment. So they allowed families to treat these folks as companions and not have to pay overtime, and in some cases you wouldn't have to pay minimum wage. And that was true whether it was family as the employer or whether a home care agency was the employer. Then about 15 months ago, the Department of Labor announced a reversal of that, and they said that third-party workers could not be treated as companions. They had to be paid overtime no matter what. And then while they were at it, they completely narrowed the definition of who is a companion to the point where very, very few workers would actually meet the criteria and actually be a companion. So it was going to squeeze, you know, a lot of the companions out of the market essentially, and create a situation where everybody had to pay overtime for really every care hour. The Home Care Association of America and the National Association of Home Care and Hospice fought fought the Department of Labor and recently won. So you might have heard a lot about companion care. You may not have heard that in the past 10 days or so, the Department of Labor had their repeal challenged, and they lost. So now we're back to status quo, and so families and home care agencies can put companions in the home, and families would not have to pay overtime for those hours over 40. But as I mentioned before, there are some exceptions in certain states, like California does not recognize companions, so they would be entitled to overtime. So just know that there's been a lot of hubbub about companion care. If you have a question about that, feel free to call, and we can guide you through that depending on your state and your situation. Next slide, please. Okay, I want to talk a little bit about workers' compensation and a little bit less about disability, but workers' compensation is the one I want to draw most of the attention to because it is a really critical insurance product. It's not handled through the tax process. It's a private insurance policy, and it provides assistance if the worker were to get hurt in any kind of worker-related accident. The policy would provide benefits that would help with medical expenses and lost wages. So you can imagine a number of accidents that could happen on the job that could create thousands and thousands and thousands of dollars worth of claims here. If someone were put out of work for 6 months and had, you know, $25,000, $30,000 worth of hospital bills, one bad car accident or slip down the steps, you name it, it can be a pretty big expense for families because if their worker has an accident in the workplace and they don't have a workers' comp policy, they would be liable for the amount of benefits that would have been paid in a workers' comp claim. So they would have that liability hanging over their head, which is why we say even if it's not required in your state, we think it's a great idea for families to have a workers' comp policy and make sure that they don't have that kind of liability, that kind of exposure hanging over their head. The other benefit to families is that if a worker accepts those benefits from the workers' comp claim, then they forfeit the right to sue the family. So if you have a wealthier client who is worried about a lawsuit and is averse to risk, I would say make sure that they are aware that they can call their homeowner's insurance agent and add a rider to their policy. A few $100s could take a lot of exposure off their plate. In the event that their homeowner's agent is not able to write a standalone policy for this, or excuse me, add a rider, we can write a standalone policy as part of our service. We have an underwriter who will do that for our clients. So just know it's a good idea, and it's not that hard or expensive for your families to get it. And if they do have a problem, they can always come to us and we can help them. Disability is similar.
Tom, before we get any further,
yes.
You know, you go through all these rules. The client is overwhelmed.
Right.
Their friends have said, you know, look, I know this woman that's been watching her mother for umpteen years before the mother died. She's willing to be off the books. It's so much easier to pay her off the books. What are the risks if you get involved with someone and you avoid all the paperwork and all those details?
Well, the risk is there are a number of ways that families could get caught. Any kind of audit or unemployment claim or Social Security, Medicare claim trying to get benefits, but the wages weren't reported. There's a myriad of ways that they could get caught, and if they get caught, they're going to have they're going to have back taxes and penalties that are going to be very expensive. I mean, this is tax evasion, and the IRS is, tries to make an example out of particularly high-profile people. But as there's a tax shortfall, and they want their money, so they will come collecting, and so families have a long-term exposure from a former disgruntled worker.
There's no statute of limitations, so you don't file returns.
Well, it depends on what you do. If you commit perjury by saying you didn't have a worker, then perjury has no statute of limitations. If you just file a tax return and you miss, it's inaccurate, then obviously that has a shorter statute of limitations. But the problem with a lot of these benefits is they tend to fall into the perjured territory, and for the worker to get the benefits, they have to, the family has to go back and pay all these taxes. So it's a very expensive mistake if you get caught. And like I said before, with the tax breaks, which I'll go into in just a second, it's really not worth the risk because the tax breaks will offset most of the additional costs. So I understand that the simplicity of not having to do the paperwork, but the IRS doesn't look at that as a viable excuse.
Thanks, Tom.
Yeah, you bet. Okay, next slide, please. And I think we're getting a little tight on time, so I'm going to run through this pretty quickly. But this is important on saving clients money. I want to make sure everyone knows there are two dependent care tax breaks that your families can take advantage of. The first is a flexible spending account through their employer, and it allows $5,000 per family per year, so you can pay for care-related expenses with pre-tax dollars. So that would save families, depending on the marginal tax rate, can save them over $2,000 a year. If they don't have access to that or they can't get into it during this tax year, the fallback is the child or dependent care tax credit, Form 2441, and that I'm sure many are aware of that. That allows an itemization of up to $3,000 per child with a cap of $6,000 total. Most of your families will see a 20% tax credit because of their AGI, and so they'll save between $600 and $1,200 depending on how many kids they have. It's important to note that there is no income restriction on these tax breaks, and they're not subject to AMT. So most of your families will be able to take it. The only thing that you have to make sure they do to qualify is that both spouses have to pass the work-related test, which means they both have to be employed or full-time students or looking for work. So as long as they meet those qualifications, then all expenses related to care would qualify for these tax breaks. Okay, next slide, please. There are also a couple of medical tax breaks that I want to make you aware of. If the care has been prescribed by a licensed medical practitioner, then these care expenses would count, and you could use a medical flexible spending account, which was $2,500 in 2014. It's been raised up to $2,550 for this year, and that'll save a family about $1,000 to $1,200 per year. And then there's also the medical expense tax deduction, which allows medical expenses in excess of 10% of AGI, unless the client is 65 or older, and then it'd be 7.5% of AGI. So those are two other opportunities to save clients money. Next slide, please. There are also a handful of compensation forms that can be considered non-taxable. So it would save the caregiver and the family money. The first would be health insurance, and recently there was a lot of hubbub about health insurance taxability and having to purchase through SHOP. We were able to get clarification from the IRS that if a family has one employee, or if they purchase through SHOP, then they can make a contribution to health insurance, and it could be and it's treated as non-taxable. If they have two or more employees, then they have to purchase through SHOP in order for it to be non-taxable. College tuition is also considered non-taxable up to $5,250 per year. So if you have a caregiver who might be taking classes, night classes or something, make sure to take advantage of that, because we can offset a lot of taxes if we structure payroll correctly. Same thing is true with cell phone service, public transportation up to $130 per month, and parking up to $250 per month. So all of those, with a few strategic questions at the beginning of a relationship, your families can save taxes for both them and their caregiver. And sometimes when everybody's struggling to try to make ends meet on the high cost of care, these kinds of things can really make a difference in terms of kind of bridging the gap between the caregiver and the family. Next slide, please. There's also another tax break that a lot of folks are not aware of. It's called the Health Insurance Tax Credit for Small Employers. And it actually allows you to take a tax credit of up to 50% of any health insurance contributions that you make on behalf of your employee, as long as you have fewer than 25 employees, which is typical in the household world. And the average annual salaries for all employees combined is less than $50,000 per year. And then the final requirement is that you purchase through SHOP. But if you do all those things, then you can take a really nice tax credit on top of the fact that it's non-taxable. So health insurance is an interesting item and topic these days, because caregivers are thinking about the individual mandate and how to get insurance. If they buy it on their own, then they're entitled to federal tax subsidies. If the family contributes, then it can be treated as non-taxable and also this tax credit. So we try to help families understand what would be the most advantageous route and how they want to handle health insurance. But it is on a lot of people's minds right now. So if you have questions about that, feel free to send your either give us a call or send your clients to us, and we can advise them on that, and no obligation and no charge for that. Okay, next slide, please. I'll just kind of summarize, and then we'll leave some time for questions. Just quickly, I hope that what we covered today makes it clear that you know, compliance is not only the right thing to do. I think we would all agree with that, but I think more than ever, it's probably the smart thing to do because of the reduced risk around labor law violations and audit expenses, and when you think about, you know, the caregiver world or the domestic world and former disgruntled employees, I just don't think, you know, families really think far in the future and think about what that might be like if they were to get a wage dispute or some sort of problem from a former employee. And really paying legally is kind of an insurance against any kind of problem in that world. If you just take care of it correctly, then you don't have to worry about any of this stuff. And then, of course, paying legally entitles you to the tax breaks that I mentioned. And if you don't pay legally, you can't take these tax breaks. So that's an important thing for people to understand. And then finally, I think families don't, you know, they want to take care of the person who's taking care of their loved one, and they really want the relationship to last forever and be professional and have consistency of care. They don't think sometimes about the benefits and protections that the employee would get if she's paid correctly versus not paid correctly. And a lot of workers are now hitting an age where they're trying to collect, you know, benefits for Social Security and Medicare and things like that. We've had a lot of unemployment claims during this recession over the last few years. And the employee is not entitled to those benefits unless those taxes are paid. And I don't think many families kind of understand what they're doing to their caregiver, and of course the risk that comes with that if they do file for some. And then the other thing is, since the recession, the financial institutions have become much more strict about loaning money or providing credit, and you really can't get a loan of any substance without having documented wages. So all of these workers who've been paid under the table, you know, really are treated almost as though they're not part of. They're almost like they're undocumented workers because they don't have any rights to credit or loans or health insurance subsidies or anything like that. So when you take all that into consideration, I think many families, you know, appreciate understanding this complex world, and they want to do the right thing. And I think as tax practitioners and advisors, like Sid was saying, I think you're in a great position to help them get through this and make sure that they don't get have any expensive problems. And we're here to support you in anything that you need to make that happen. Next slide, please. I'll kind of wrap up now. Real quickly on the resources, and then I'll open it up to questions. We have booklets that we can provide for you and your clients. I mentioned free calculators. If you go to myhomepay.com, you can get budgeting calculators for your employers, for the clients, and then paycheck calculators for the employees so they can understand their take-home pay. We also have a library that has state-specific requirements, so feel free to click on your state, and you can find out all the nuances in both the tax and the labor law side, and make sure that you're advising your families correctly, or give us a call. We have experts here. We're happy to help you or your families for free, so just give us a buzz. So why don't I open it up now to questions. I don't know, Sarah, have we had any questions?
We do. We actually have quite a few, and I do want to mention that we will provide the PowerPoint deck to all the registrants. We'll email that out, and we'll try to go through as many questions as possible, but we'll certainly follow up, you know, on any questions with our answers in case, you know, folks have to drop off. But okay. Thank you again, and thank you, Sid, and let's go to the first question. Could you run household employee expenses through the company, but then treat the payments as distributions?
That might be a question for Sid. I don't know. That doesn't.
I don't think you can do it.
I don't think you can either.
Okay. second question was, is workers' comp needed if the employee goes into an assisted living facility, not the taxpayer's home, for added care to the individual?
That would be, it's a great question for the assisted living facilities. I've seen contracts that were set up where the family was the employer and the facility was really just providing a workplace, but not taking any responsibility for the environment or any kind of accidents. So in that situation, which I think is fairly common, workers' comp would be required, because it doesn't really matter in that instance whether it's in home or in a facility. If you're the employer, you have responsibility for the safety of the work conditions for that employee.
Okay. The next question was, are the rules different if you hire a nanny from a foreign country through a service?
Yes. If you hire if it's a sanctioned au pair, then it would be different. The State Department has a list of approved au pair agencies, and they can provide au pairs to families, and the tax requirements are completely different for families if they have an au pair. There are some other restrictions as well on number of hours and things like that. But if it's not through one of those sanctioned au pair agencies, then it's not, then essentially the tax laws are the same as it would be for a U.S. worker.
Okay. We also got, can we issue Form 1099 instead?
That's kind of drawing attention to the worker misclassification slide. The 1099 is designed for reflecting payments to an independent contractor, and the IRS says no, those workers should be given a W-2, not a 1099. In 99.9% of the cases. If you're not sure about it, feel free to call, and we can kind of walk through the situation and the conditions of the employment, or you can file Form SS-8 with the IRS, and they will give you a formal ruling on whether that worker can be considered an employee or an independent contractor. But as I mentioned before, almost every time it's landing out on the side that the family is the employer.
I have one more question, Tom.
Okay.
I have a couple of clients that need to go back 2 or 3 quarters. Does HomePay handle retroactive filing situations?
Absolutely. We have many of our clients come to us with retroactive filing situations. They're 2 or 3 quarters delinquent. We go back and file those state returns and handle all of the catch-up payments and everything. And we also are able to, in many cases, get the penalties waived for first-time employers, because we file a petition with the state, a waiver, to get those penalties waived. And if it's a first-time employer, often we've had great success getting the penalties waived. But we take care of cleaning up that, even if it crosses multiple tax years. We handle retroactive work, so we can certainly handle that for you.
Okay, and one more question here just came in. Will the executive actions on immigration reform have any impact on families?
Wow, that's a great one, and I almost added that to the very first slide, the introduction slide, on what is going to make an impact on this world. The executive actions are kicking in soon, and essentially whether we have comprehensive immigration reform or not, the folks who are applying for the DAPA or the DACA status will have to show that they are paying their taxes. So paying taxes is going to be a critical component, and for that reason, families who are currently hiring an undocumented worker will be impacted by whatever legislation we end up with. It's not clear right now as to what the exact details of that will be and how they need to handle it, but we're watching that closely. But they will have to figure out how to pay taxes for their employee if she wants to be able to stay in the United States and keep her work status. So yes, the answer is yes. There are still a lot of details to be ironed out depending on what Congress decides to do in the coming months.
Okay, great. That was it for questions.
Okay, wonderful. Well, thank you for spending time with us today. We appreciate you being here, and have a great tax season.
Tom, can you call, please?
Sure.